Tabiseng, thanks a lot for joining us this afternoon. Now, there is an argument that particularly when it comes to these types of cases, having the victim actually rehash the sequence of event is almost resulting in reliving the trauma, which does not necessarily do anything for the healing process of that individual we're trying to help.
Well, it is true. It is reliving the trauma that the person went through during the rape ordeal or whatever kind of ordeal that the person suffered as a result of what's happening. However, considering this specific case, the plea of guilty that Nicholas Nino gave was not accepted by the state, which means he did not meet all the required elements to an admission of guilt in terms of the Criminal Procedure Act. So his plea explanation in terms of Section 115, I believe it would be, then he didn't comply with, he didn't meet all the elements because every crime has to have its own element that you have to meet. So he did not comply with that. So I'm sure that his evidence that he gave regarding the plea will be admitted in terms of Section 220 of the Criminal Procedure Act. However, it doesn't mean that it bridges the gap in terms of the healing process, because there are social workers that are involved, there are psychiatrists that are involved, the teddy bear clinic is also involved, and as the child in this specific case gives evidence, an intermediary is usually there to assist the child if the child is not able to give evidence on their own accord. And this applies for any child who is 18 years and below.
I mean, obviously there's a certain regulation and process that goes into it and thought behind it. However, I mean, even if you, as you're saying, it almost focuses significantly on the individual who's seen as the perpetrator or the accused in this instance. In other words, Nino did not give all the elements that are actually necessary for a guilty plea to be accepted. So it's almost focusing the attention here on the accused as opposed to the effects that the victim gets. So even our mindset and our perspective on this is more focused on how do we get this guy behind bars and how do we get him to, it's more about him as opposed to for aligning to her as well as her needs at a particular moment in time, especially given her age. I mean, 8 years old, one would wonder how is it that she became so brave?
Well, it's not something new that a child of her age testifies. In fact, I've seen kids who are 5 years old give evidence in court. You must remember that before the matter actually goes into court and actually before the evidence is given, the prosecutor who is handling this case has a lengthy conversation and discussion both with the victim's family, with social workers involved, intermediaries. A lot of things go into play. So the emotions of the victim is what you don't see in the background, is already taken care of. So what we are focused on, you're 100% right, is getting the perpetrator behind bars. The emotional aspect that the victim has suffered has already been dealt with, and it continues to be dealt with. It doesn't mean because we are making sure that when we find the accused guilty and then a sentence is imposed upon him, it is a correct sentence that will remedy the effects of what he did. It does not mean that the victim has now been shunned or put aside. There's a lot of things that go into the background before what we see on television regarding cases.
I mean, is this going to now strengthen or weaken in terms of, the prosecutions at this particular moment in time? Because one would say that actually hearing from the victim himself might give the critical evidence that is needed, especially when it comes to closing arguments. But so does it strengthen, or in this case, give more insight and more base and substance to the prosecution's case?
Both. It will strengthen and gives a lot more information about what happened, right? And you must remember that already the accused has pleaded guilty. So his admissions are going to be viewed in terms of Section 220 of the Criminal Procedure Act. So it's already evidence that is accepted. He's already accepted that he's pleaded guilty and accepted that indeed he's committed the crime. You know what I mean? So at this stage, the state has a very strong case against the accused, and the witnesses are not being cross-examined. So I do not think once the state closes its case that the defense will open its case. So it's already they've pleaded guilty.
As an attorney, would you think that the state is actually going to try to make an example out of this particular case, that, especially when it comes to Nicholas, as well as the events in itself? I mean, it's highly publicized. It's got, we reporting on it. We've got different media houses that are going to be reporting on it as well. Does that then make it one of those cases where somebody will try to actually make an example out of Nicholas now?
Well, it shouldn't be that way, that the state, because this case is so public, that they choose to make an example out of him. They must apply the letter to the law. And you must remember that at the end of the day, even if the state has proven its case beyond a reasonable doubt, the last word is not with them. It's the presiding officer, who is the judge in this matter, who will then make a sentence based on the evidence that is there. So the state can do as much as they can. But if the presiding officer feels that there's sufficient evidence to pass the minimum sentence, then we're still stuck in the same place that we were at.
Tabi Singh, thanks a lot for joining us this afternoon, shedding some light in terms of the significance of her hearing the testimony from the 8-year-old survivor, as we heard it today in court. She was articulating the sequence of events that actually led to her rape, trying to establish the case, and also, most, as you heard now, beef up the prosecution's case.